commit assault. A person commits the offense of assault if a person intentionally, knowingly, or recklessly causes bodily injury to another. Have means to intrude any part of the body or any physical object connected to the body. Bodily injury, as defined in this charge, has the same meaning here. Effective consent means assent in fact, whether express or apparent, and includes consent by a person legally authorized to act for the owner. Owner means a person who has title to the property, possession of the property. A person acts intentionally or with intent with respect to a result of his conduct when it is conscious, objective, or desire to cause a result. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious, objective, or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause a result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that circumstances exist. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware of or consciously disregards a substantial and unjustifiable risk that the circumstances exist or a result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. You are instructed that the defendant is not required to prove the justification, defense, or protection of one's property by using deadly force. The state has a burden to disprove this defense, meaning that the state must prove beyond a reasonable doubt that the defendant's conduct was not justified by any defense. Any of his defense.
I'm sorry.
Yes. person knows or should reasonably believe that the other will regard the conduct as offensive or provocative. Okay, y'all both agree that I was on now, keeping in mind these instructions?
I believe it. Yes, Judge, I believe that's correct.
That's correct.
Okay, now keeping in mind these instructions, even if you unanimously find the state has proven beyond reasonable doubt that the defendant Mason Lubitz committed the charged offense of murder as instructed in paragraph 4, you must next decide whether the state has proven beyond reasonable doubt that the conduct of Mason Lubitz was not justified by using deadly force in self-defense, and that his conduct was not justified in using deadly force in protection of one's property. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, Mason Lubitz, committed the offense of murder as charged in the indictment, but if you further find from the evidence that, or if you have reasonable doubt as to whether at the time he did so, 1, Mason Lubitz acted in self-defense, and that A, Mason Lubitz reasonably believed, or is presumed to have reasonably believed, as viewed from his standpoint, that Trevor James Beeman was using or attempting to use unlawful deadly force against Mason Lubitz, and B, Mason Lubitz reasonably believed, or is presumed to have reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself against Trevor James Beeman's use or attempted use of unlawful deadly force, and C, Mason Lubitz's use of deadly force was not in response to verbal A, Mason Lubitz was in lawful possession of land, and D, Mason Lubitz reasonably believed the use of force was immediately necessary to prevent or terminate Trevor James Beeman's trespass on the land, and C, Mason Lubitz reasonably believed that the use of deadly force is immediately necessary to prevent Trevor James Beeman's imminent commission of burglary, and D, Mason Lubitz reasonably believed that the land could not be protected by any other means or the use of force other than deadly force to protect the land would expose Mason Lubitz to a substantial risk of death or serious bodily injury. Then you will acquit the defendant, Mason Lubitz, and Lubitz committed the offense of murder as charged in the indictment and as instructed in paragraph 4. And if you further find from the evidence beyond a reasonable doubt that 1, Mason Lubitz did not act in self-defense, and that A, Mason Lubitz did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that Trevor James Beeman was using or attempting to use unlawful deadly force against Mason Lubitz, or B, Mason Lubitz did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that the use of deadly force and degree of deadly force used was immediately necessary to protect himself against Trevor James Beeman's use or attempted use of unlawful deadly force, or C, Mason Lubitz's use of deadly force was in response to verbal provocation alone, and Mason Lubitz did not act in protection of one's property, and that A, Mason Lubitz was not in lawful possession of land, B, Mason Lubitz did not reasonably believe the use of force was immediately necessary to prevent or terminate Trevor James Beeman's trespass on the land, or C, Mason Lubitz did not reasonably believe that the use of deadly force is immediately necessary to prevent Trevor James Beeman's imminent commission of burglary, or D, Mason Lubitz did not reasonably believe the land could not be protected by any other means, or the use of force other than deadly force to protect the land would expose Mason Lubitz to the substantial risk of death or serious bodily injury. Mason Lubitz was not justified under the law of self-defense, and that he was not justified under the law of protections on one's property. Mason Lubitz guilty of the offense of murder as charged in the indictment. Certain exhibits entered into evidence in this case have portions of those exhibits redacted, edited, or muted for sound. You are instructed that you are not to speculate about the substance of those redacted, edited, or muted portions of the exhibits, and such portions may play no part in your deliberations. All law provides the defendant may testify on his own behalf if he elects to do so. This, however, is a right according to the defendant. In the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant is elected not to testify, and you're instructed that you cannot and must not refer or allude to that fact throughout your deliberations, or to take it in consideration for any purpose whatsoever as a circumstance against him. You're instructed that you must not communicate with telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, or Twitter, or X. To communicate with anyone any information or receive any information from anyone about this case, or to conduct any research about this case until police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times statements and reports may be marked with an exhibit number but are neither offered nor received in evidence. I consent only statements and reports received in evidence to the jury room. You're instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by the evidence, these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is a means whereby a defendant is brought to a trial on felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters and evidence before you. You must not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching the verdict in this case. After argument of counsel, you retire to the jury room. Select your own presiding juror, proceed with your deliberations. After you've reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court which is herein given to you and be governed by that law. The burden of proof in all criminal case rests upon the state throughout the trial and never shifts to the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is a consideration of all the evidence in the case. The prosecution has a burden of proving the defendant guilty. They must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. The only duty at this time is to determine whether the defendant is guilty under the indictment of this cause, and you must do nothing else. After you've retired to the jury room, no one has authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Okay, there's a verdict form for not guilty and for guilty. Side, 40 minutes. In addition, when you have, there should be a buzzer back there. Push it up to the sign says, or whatever the sign says, I believe it's 1 is a note, and then 2 when you have a verdict. The deputies will go back there. They're just going to make sure you have a verdict. Don't tell them this is what the verdict is. Whoever the foreperson is going to sign it, put it in this envelope. It's not going to be told to
state would reserve any extra time for rebuttal. Judge, defense counsel. Good morning, everybody. This usually begins the part where you hear from all four of us, and the very first thing we all say to you is thank you. And I always like going first because it means I get to be the first one to say it and not the one who says it, for the fourth time. Y'all's experience with this trial has been unique because of this freeze and how long everything has gone for. And so I do appreciate you. I know you're going to hear from the other guys, but we do appreciate you, and I just wanted to start off by telling you guys that. Now, I have a few points. We all just heard the jury charge, which is this series of papers. I want to very briefly talk to you guys about it first because it's a lot. And the first thing I want to point out is this very first page, which says the charge of the court. And it is on this first page that the charge of murder is defined. And on it, you will read that our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual, or if he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. Now, what's about this trial, as opposed to other trials that happen in this building, is that throughout this whole week that we've been here, that hasn't really been contested. Whether or not Mason Lubitz killed Trevor Beeman is not a question at hand because of all the testimony that we've heard. Everything about this case lies in that next part of the jury charge, which is where we talk about self-defense, and we talk about provocation, and everything like that. The very first thing I want to tell you guys is more. Now, I also want to give you a heads up about how everything's going to kind of play out from here. Obviously, I'm talking right now, so I'm going to go first. After I finish and I sit down, you're going to hear from both defense attorneys in back to back. And then lastly, you'll hear again from my colleague, and we're going to talk a little down. I want to talk to you all about how there are certain things you've heard in this case that should be sitting at the back of your mind. And everything that you're about to hear from them, there should be something else sitting in the back of your mind that says, well, hold on. That's half of it. Over the course of this week, we heard so much about how the defendant was afraid and he was terrified. At the back of your mind should be if you're terrified. Why do you confront the person? Why do you seek that out? Because the behavior doesn't match the emotion. It doesn't fit. It should be in the back of your mind. In the back of your mind should be that photo, those photos of Trevor Beeman lying lifeless outside of the apartment. The blood pools, the blood stains, everywhere the blood went. Everywhere. It should be in the back of your mind. Because a lot of the arguments you're going to hear about, well, he must have gone in, the body doesn't tell that story. It doesn't fit. And that should be in the back of your mind. Now, also in the back of your mind is every single time that we've heard in this trial, the defendant referenced Trevor Beeman dying. Whether he said he wanted Trevor dead, or that time he referenced murdering someone or wanting to murder someone, or I'm going to kill somebody, or I hope he dies, or I would have killed him then, or I'll kill him in front of his girlfriend, I'll kill his girlfriend in front of him. Every single time he said that, it should be in the back of your mind. And they should be in the back of your mind because those things were true before the murder, they were true during the murder, and they're true after the murder. And nobody can change that. Those things should be in the back of your mind because they're half of every single point that they can try and point out to. Every single aspect of this case that they can point to half of those truths are, well, what about these other things? And it should be in the back of your mind the entire time. They should be in the back of your mind because at the end of the day, after I sit down and they sit down and my colleague sits down, those things are then going to come to the forefront. Because those things are the reason why when you do go back there to deliberate and you sit down and you talk about it and you try to remember everything that was said and how it was said and is the way that they said it really what they said? Because you only get to hear those things back if you disagree on what you remember what was said. When you're back there now, after hearing all of that, those things that are in the back of your head are the reason that you're going to come back and find him guilty of murder. Thank you, guys.
All right, maybe have a moment to set up.
Yes.
You can suppose that they don't know.
State's gonna have 33 and a half minutes left.
I'm sorry, Judge.
You're gonna have 33 and a half minutes. You're gonna-
Thank you, Judge. Appreciate it.
Please the court and ladies and gentlemen of the jury, you haven't heard as much from me during this trial as you have from Jason, but I'm going to get up and give you the beginning part of the defense's argument. I'm going to talk to you for a few minutes about the law. That law that the court read to you, that is your Bible going forward in making the decisions in this case. That is the only law that applies in this case, and those are the decisions that you are going to have to make. And by the way, in case nobody mentioned it, you will get a copy of that charge, so don't think you have to memorize everything the judge just told you. So you will get a copy to take back. The first thing, and what I think is the most important general concept that will apply to your decision-making process, is who bears the burden in this case. Always the state. Now that's easy when it comes to, well, have they proven murder beyond a reasonable doubt? Well, I do agree with my colleague that murder, whether a homicide was committed, is not at issue. What's at issue are the defenses in that charge, whether it was justified. And who bears the burden in those? The state bears the burden to disprove those beyond a reasonable doubt. The defendant, this is from the charge, the defendant is not required to prove self-defense. The state must prove beyond a reasonable doubt that the defendant did not act in self-defense. And I say that's the most important thing because that's not usually how we reason outside of courtrooms, but it is absolutely essential to the process and to our system of justice. So the burden of proof, how does that really operate when we're talking about self-defense? Well, you might remember this little chart from jury selection. And, well, if you think it may not be self-defense, not guilty, possibly not self-defense, all the way through, well, it's probably not self-defense, still not guilty. Less than likely self-defense, not guilty. What if you think it's highly that it's not self-defense beyond a reasonable doubt that the law permits you to find Mason guilty of this crime? So and they're not wrong about that. If something was proven to you beyond all doubt, well, you probably witnessed the event, and you wouldn't be a juror, you'd be a witness up there on that stand. But suffice to say, if you have a doubt in your mind as to anything the state has an obligation to prove, and you think that doubt's reasonable, that means not guilty. So the justification of self-defense, we call these things defenses, but they are more properly termed justifications. We believe, as viewed from his standpoint, that's another important point, you're going to have to actually, you're going to have from Mason's standpoint, because that's the perspective that matters here. That Trevor Beeman was using or attempting to use unlawful deadly force against Mason, and Mason reasonably believed, again from his standpoint, that his use of deadly force was immediately necessary to protect himself against Trevor's use or attempted use of unlawful or deadly force. Okay, those are things that the state has to disprove to your satisfaction. Use of deadly force cannot be in response to verbal provocation alone. Now, a threat saying, "Do you want to get slapped again?" That's different than verbal provocation. Trevor's threat is different, and you have to consider everything that happened before between Trevor and Mason, including that October 4th decision process is going to be simplified. Those two elements, 1 and 2, they are presumed under the law of this case. So, or is attempting to enter your home. And the law says, well, that presumption, that issue, well, was the person reasonable in using self-defense? Was the person reasonable in thinking that someone was going to use unlawful deadly force against him? Well, the law says if it's in the home under certain circumstances, the law makes that decision for you. You do not have to make that decision. So the presumption of reasonableness, how does that apply? Well, presumption is a fact that is to be taken as true, and the court's charge uses the word must. You must find. If you find certain circumstances, you must find this presumption to be the case. So the presumption says that under certain circumstances, you are to presume that the defendant's belief that deadly force was immediately necessary was reasonable. And I can tell you right now, we do a fair number of these murder cases. Not many of them happen in the home. So most of if you find this presumption applies, I'm not going to call your decision easy, but it is greatly simplified because the law has already made that very hard decision for you. So, again, the state bears the burden to disprove these things such that the presumption will not apply. So you must find it to be immediately necessary. That Mason either know or had reason to believe that Trevor Beeman unlawfully and was force entered or was attempting to enter. We heard a lot about, well, did he actually enter the apartment? Was he shot outside the apartment? Was he entering? Was he attempting to enter? If you believe that Mason had a reason to believe that Trevor Beeman was attempting to enter his apartment, but with force, that's all that required. And by the way, just real quick on the matter of force, now, force can be applied in a number of ways. You'll remember Jason's example where he walked through those gates. He manipulated the gate with his hand. That's force. It doesn't have to be kicking in the door the way we saw the officers did. That's one force. Force can also be turning a doorknob and pushing a door in. Force can also be pushing open a partially closed door. That is force. It's just physical manipulation of another object. Was attempting to enter Mason's habitation. I don't think anybody's disputing that this was Mason's habitation, this apartment that he lived in. And the state has to prove that Mason disprove that Mason provoked the person against whom force was used. Now, provocation, that's going to be something that you're going to hear them argue a lot, and you're going to hear Jason respond to that as well. But I want you to bear in mind what provocation means in these arguments. Mason was not otherwise engaged in criminal activity. I don't think they're going to argue that he was. That's part of the law. But Mason, he wasn't dealing drugs. He wasn't doing anything that was actually any kind of illegal activity in that apartment. So that part's pretty easy. Okay, another part of the defense, part of the jury charge is the deadly force in defense of property. Again, this is when the state has the burden of disproving beyond a reasonable doubt. So they have to disprove that Mason was in lawful possession of land. I think land here, that's a word we use, it just means real property you have a right to possess. So land includes apartments. Apartment dwellers are big ranches are. They have to disprove that Mason reasonably believed that force was immediately necessary to prevent or terminate Trevor Beeman's trespass on the land. What is trespass? That's entering or attempting to enter without your consent. That's all trespass is. Trevor did not have permission to enter that apartment or attempt to enter it. He was attempting to commit a trespass. Also, Mason believed deadly force was immediately necessary to prevent Trevor's imminent commission of burglary. Now, we usually think of burglary as theft, breaking into somebody's house to steal something. But in that jury charge, you're going to see it also includes unlawfully entering someone's habitation with the intent to commit assault. And that's why you've heard us arguing about assault, and you're going to get a supplemental charge on assault, because assault can include threat, include offensive contact, slap to the face, whatever it might be. Remember, do you want to get slapped again? And either the land could not be protected by any other means, there was no egress to this apartment, substantial risk of death, or serious bodily injury. You'll recall those videos of Trevor boxing. Well, he wasn't wearing gloves today, and you saw how hard he could hit with it. Mason saw those too. Okay, I'm about to sit down, but one thing I do want to point out in this charge is the Fifth Amendment right. Now, the judge has instructed you that you cannot or must not refer to the fact that Mason didn't testify. That's a Fifth Amendment right we all enjoy if we're ever unfortunate enough to find ourselves in the seat that Mason's sitting in today. And I've actually found over the last 20 years that jurors are remarkable. Gave you the backstory. Remember, we brought in Jenna, who told you a whole lot of stuff that Trevor, his reasonable belief and everything that he knew. We also brought you Spencer, that's Mason's brother, who was able to fill in some of those gaps and corroborate some of the things you heard Jenna testify. But the fact that Mason didn't testify, law says you can't hold him against him, and we ask you please do not. Okay, I'm about to sit down, and Jason's going to stand up and give you the remainder of the defense argument.
It's the first thing I told you guys. Trevor Beeman's actions caused and was responsible for Trevor Beeman's death. And the trial, what we've seen throughout the trial is that. It is that fact that has gone through everything. And now, the prosecution said, well, there's always going to be this thing in the back of your mind. There'll be this thing about provocation. There'll be this thing about this. And we'll talk about a few of those things. But ultimately, what Patrick told you guys is that when we get to the end of this, there is the presumption. The presumption means you thought he might, whether he could have. I mean, anybody who knew Trevor, as you've seen in throughout this trial and how that's developed, could assume that he did, right? But regardless of that, what the presumption says is that anybody coming into your house, no matter what, if they're doing certain things, like using force to enter, meaning they're coming in unlawfully, and they're threatening at the same time, anybody who's doing that, it is presumed to be reasonable that they're about to use deadly force against you. It's the protection that we have for our homes. I think all of us know that. I don't know that any of us, before you came in today, before I practiced law, before any of this stuff, I don't think any of us had a doubt in our minds that people can't come into your home. That people can't come into your home and threaten you. And that if somebody does come into another person's home and threatens them, then that person is within their rights to use deadly force. I know that Mr. Beeman knew it. And we're going to talk about that. I know that he understood it at the time while he was watching what was happening. And that's one of the most important parts of this, is how are they going to overcome a presumption and how are they going to overcome a burden when their eyewitness, who was the person, deceased father, felt himself at the time that Mason was within his rights. So let's talk about that. First, Mason was telling the truth. And that's one of the things that have kind of come out through this. It's kind of, it just feels like, he's a little odd, right? I mean, he's a little different, neurodivergent, a little strange, the way he talks, the way he tries to explain what happened, all of those things. And it seems like to me that because of that, they said, we don't care. We're not going to listen to your concerns. I mean, he's literally 6 feet across from somebody. And now, from the beginning of the trial, when you heard the Beemans testify, when you heard Mr. Beeman, and look, I told you, I have respect for Mr. Beeman. I don't think he's a bad guy, right? Obviously, there's a lot about his son he didn't know, right? But Mason knew it because he had to live next door to him. Jenna knew it because they had to hear it go through the walls every night after night. This guy is beating his wife. He is beating Maddie. He's hurting her. Maybe she's beating him. But whatever it is, when you're hearing it through a wall, it's disturbing, it's terrifying, it's scary. Oh, brother, what do? She's over here now. She's seeking shelter in our house away from him. He's like coming over and beating on the door. And Spencer said, look, they go back a lot. So what'll happen is go back and then, where are you? Where's Jenna? This guy's mad. He's angry. He called the police on a violent guy doing violent things. But they did it. And then what did you hear? The police goes over and goes back. When we had our first baby, my wife, she drove to daycare, and there was always a police officer that sat there. And when you have a baby, everything kind of goes crazy. Her registration expired at the same time, and I couldn't get there to get it redone. And she couldn't, obviously. And she's trying to take him to daycare. She's starting back at work. And this police officer would pull her over every time, for her expired registration, and gave her a ticket, and she says, look, we're trying. My husband, yeah, okay. Where's that guy? That guy that's pulling. Where's a guy that actually cares that he's going to follow the law? Where's that guy to go into the apartment and say, hey, there's got to be a girl here? No, two guys there say, only males, all males, only males, all males. Maddie's in the back. They don't even look in there. So now you have Mason. He's telling the truth, but nobody cares. He's telling the truth, nobody listens.
He can fight real good. He showed me videos of him beating the shit out of people. So I see my size.
What color hair does he have?
He can fight real good. He showed me videos of him beating up people twice my size, and he's got weapons. Well, what are we showing? You know, look, some people do that. Nobody's here to say, oh, it's a horrible person, backyard boxing, whatever. You know, I haven't been to one of those. Maybe some of you have, maybe not. But it's not the point. The point, I'm not showing you this to say, oh, he's so bad. I'm showing you this to say he can be dangerous when he wants to. I'm showing you this to show Mason told the police, I've seen this guy. I know that he can cause a lot of damage with his fist. I know that he can cause a lot of damage to me. I can't go against somebody like that. He can fight real good. I watched him beat the shit out of people. You know, and if any of his language or my language, or the language you've heard in the trial offends you, I apologize for it now. Please don't hold it against him. It's just, people talk like that. We have it, right? Like everything he says, guy, he hit me here. Police didn't do anything. They investigated. They didn't really do anything until December 22nd. They gave him a phone call. But then Maddie came in and told you, everything, all of that was true. Everything that Mason is saying is true.
Fuck my glasses up, fuck my face
So
up.
as far as-
I feel that's always bringing people here threatening me.
So you're wanting to press charges?
Oh, yeah. And I'd like to also, can I now add testimony to him beating his wife the other day? Am I allowed to do that, or is that not?
I have no idea what
I'll say that you call me to the fucking stand. I'll tell you everything I saw.
Maybe the police officer can maybe say like, well, hold on, let me get you in touch with a detective or somebody. A woman's getting beat up. I don't think they believed him, you know? That has to be what it is, because it's not normal. It's not normal for a police officer to hear that somebody is beating up their wife and not want to know anything else about it. Well, if they don't believe him. But then, of course, Maddie comes up and it's true. Everything that he was saying is true. And so when he says he's terrified of Trevor, the prosecution wants you to go, well, yeah, that was true what he said. Yes, and oh, and that was true what he said. And oh, that was true what he said. And oh, that was true what he said. But don't believe that. And it's wrong to do. It's wrong to say. It's wrong to argue. It's wrong to say he is telling the truth. Oh, but you don't know if his dad really said this thing about killing him or whatever. And look, here's the other thing too. One of the things about a case like this is when you have this much volatility, and he's talking to a police officer saying, yeah, I want to kill him. I don't know anybody who gets slapped like that and doesn't want to kill the person, right? But he said, I didn't. I did not do that. He said, I didn't do anything. I didn't do anything. But I will not let this man do something to me to where I could get hurt or killed. And that's it. So if he goes, yeah, I wanted to kill him, well, then later, of course, it looks like, oh, hindsight, oh my gosh, and he did kill him. But that's not how this works. We don't go, oh, he said it before and now he did, and so that must be that he was planning on doing it, because it ultimately comes back to Trevor Beeman's actions. Trevor Beeman's actions, solely and alone, were responsible for his death. And he had terrorized and assaulted, and Trevor was just ready. He's going to show, I guess, show his dad, show whoever. This is the guy I slap around out to have him do that. And that's the right that every one of us have. And you may say, well, maybe he could have done something different. That's not what the law says. The law is not talking about what's the most ideal thing. It's does he have the right to not be convicted. Trevor doesn't go in there, Trevor's fine. There's no dispute in this case that Trevor Beeman was a violent man. The state's own witnesses came and told you that Trevor was a violent man. Any man who beats his wife like that, any man who does that is a violent man. Dangerous man. Somebody that if you're his neighbor, you would be concerned about and you should be concerned about. That's it. And no dispute He beat his wife, he assaulted Mason, he's skilled in hand-to-hand combat, there's no dispute about any of these things. He owned a firearm that he'd carry on and show off, and carry in his waistband and everything else, right? We know that for a fact. Maddie told you. Mason told everybody that would listen. But Maddie told you as well that that is true. And then Jenna told you as well that she saw it. There's no dispute that he was a drug user and drank alcohol. What is important about that? An 8-ball is a lot of cocaine. It's just a lot of cocaine for two people. It's a lot. So if they finished it all that night, maybe they did. I don't know. But that means they got an 8 balls worth. That's 3.5 grams. Like a big old, like that, of cocaine that they're snorting. Christmas Eve, before the family all comes the next day. And not just that night. Remember, they didn't go to bed till 3, 4 in the morning, right? So this cocaine to the point where he can't drive. He's so intoxicated. And we talked about it in more dire. If you have any questions at the end of this, it is them that has to answer those questions, right? The state has to answer any questions. Well, did Trevor do it that morning? And it really doesn't matter, just to give you an understanding that, like, look, this guy, like, not only is there no dispute he's violent, is there no dispute that he's violent to Mason, but he's also doing things that reduce inhibitions. And it makes you do stuff like run up in some other guy's apartment, open the door, and threaten to assault him. Bad move. It's always a bad move. It's not the right, reasonable, rational thing to do. I don't care what him or to his father. Because the things that Mason was saying is not something that would provoke a normal, reasonable, rational person to go into another man's house and threaten to assault him. You know? It would... What's that? I don't know. The guy's mad at me. I slapped him. I screamed. Whatever. That's what normal people do. Or, like, well, something's wrong with him. You can go inside the house or whatever. He's obviously pissed off, Trevor. And he thinks the one day that he can come back and move out, and we're all here. Because the whole family, I don't even understand that. Well, we wanted to have a humble Christmas by all gathering into this apartment. But they also told you, and it's clear, that there's no reason to expect that he would be there. That Trevor would be there. That the family would all, like, crowd into that apartment that Christmas. Turns out that they weren't. It's a tragedy that they did. But ultimately, there is no dispute about these facts. They're not going to come up there and tell you that. So he actually saw. Because he went and talked to a detective that day and told him. And you heard me, and I got it out of him. Today, when he testified, he saw something different. You also said were these things. There's a lot of stuff added in 3 years. I'm not here to say anything about him. I get it. I understand it. Right? Like, there's a lot of stuff he had to say on the stand that I'm sure it was hard to say from his family. That may not have known that what he said to the detective on the day of. But that does not mean that, oh, well, we feel bad about that, so let's convict him of murder when he did not. Because if you look at what Mr. Beeman saw, the first thing he said to the detective when he's describing it, and I went over this over and over with him, but the door was obviously shut by the time Trevor got to the steps, went to his apartment, turned his doorknob, and pushed it open. That's what Mr. Beeman said to the detective about what he witnessed, feet away from what's going on. And I think he may have stepped in the doorframe. And then Trevor, I thought he said he once slapped or something. So what he is describing right there is a burglary of a habitation. That's what he's describing to the detective watching his son do. That is a burglary of a habitation. That is your presumption. He is describing that Trevor unlawfully used force to go inside this man's apartment, and he may have stepped in the doorframe. Okay, so if he may or he may not, that's a reasonable doubt. And where do reasonable doubts go? That's against them. They have to prove to you beyond a reasonable doubt that he didn't. In their own witness, the eyewitness, the father of the person who died, this is what he said to the detective. He said something different to you. And I think we can all understand why. We know that Mason did not and could not have opened his own door. So I know that there was some suggestion that maybe it was like he walked up there and he was going to knock, and like Mason opened the door and shot him like that. There was that kind of suggestion, but we know for a fact he didn't, because all the forensic evidence proves the shots were fired from a distance, farther than at close range. All the forensic evidence proves that. You have these shell casings. that are grouped here. Somebody with a half wall, that's why I was talking about it so much, who's right at the door is shooting. Those shell casings are going to be bouncing and staying in that hallway. They're not going to group together all back in this living room, suggesting that the person was back at the living room or a little in front when he fired. They won't do that if he's right at the door doing that. So that's the first thing. Second, gunshot wound. No evidence on any gunshot wound or close range firing. That's the only reason with that medical examiner. You might have gone, why are they going through it so much? It's because you know for a fact he didn't stand over him and shoot him. You know that because it would be way within 3 feet, the end of that muzzle to the body. And there's no evidence of that. But you also know for a fact that he didn't open the door and shoot because he's still within 3 feet. That would be evidence of close range firing. You clear the rifle around the door and you shoot. You would have close range firing from right there. You would have to. So that's not what happened. And we know that's not what happened because the door was obviously shut by the time Trevor got to the steps, went to his apartment, turned his doorknob and pushed it open. The day of. Right then. That's what Mr. Beeman saw. That's what he saw happen. And it's true. That is what happened. And then he said later on to Sergeant Henning, that's what bugs me about this. I mean, the guy, and I clarified, I said, when you said the guy, you're talking about Mason. And he said, yes. The guy is probably within his rights if somebody comes into your house and threatens you. That's what it is. And then they go, and everybody goes, well, maybe he doesn't know. He's not a lawyer. He doesn't know the law. He's an eyewitness. And that's his child. And I'm telling you this, it has to be true because nobody would say that about after just seeing their child shot. Nobody would say that unless that's really what they saw. That's it. I was thinking about it, I don't care if my kid ran in there with a gun. Guy should have shot, right? He's an honest man when it comes to that. When he was talking to that detective, he honestly said what he saw. There's no way that he would lie about that. So if the eyewitness says he's probably within his rights, and they have to prove beyond a reasonable doubt that he wasn't, when there's a presumption that he was, Mason is not guilty of murder. Because if you found him guilty of murder, you would be saying you are guilty of murder even though the person who was killed's father told the detective he thought that you probably were within your rights. Probably within your rights is not guilty. Probably not within your rights is not guilty, right? Even if you came in and said, I don't know, maybe, probably not, probably. Those are all not guilty. That's not beyond a reasonable doubt either way.
They're right outside on the doorstep.
Okay, listen, they're dead, man. Okay, listen, you stay where you're outside. I really want you stay where you're at. I'm not gonna hurt you. All right, tell me that. Don't go out. He fucking said anything else.
He's saying it was him and he's the only one.
So what Mason screaming is he came into my apartment and he was threatening me. And then what did Mr. Beeman say? He's coming into his apartment, threatening him. How's Mason screaming that? Knowing, he didn't know that Mr. Beeman was going to be the witness that backs up what he's saying. He's screaming that to the police officers at the time. He came into my apartment. And look, all of this, everything, it's obviously emotional. It's emotional today. It was emotional then. Please don't hold that against him. Because how he reacted after this happened, we've had more than enough testimony from all the officers and everybody who's ever seen this, that when you shoot somebody, you never know what they're going to do and how they're going to react. So, but one this guy is not going to go and do not the same as their son, right? Like they obviously their son has got issues, violent, everything else, but he doesn't think that this is going to happen. And so he never thought that. I mean, nobody would. So he's saying, like, your son ruined my life or whatever. Trevor doesn't do anything. Trevor doesn't go up there. Trevor doesn't go in. Trevor doesn't open the door. Trevor doesn't say, you want me to slap you again? You want to get slapped? You want me to slap the shit out of you? Or whatever it was that his father said. He doesn't do any of that. Nobody gets hurt. How do you know that? Because Jim Dean was sitting right out there right after his son was shot. He said he saw Mason again. Did Mason shoot him? No. Did Mason shoot Trevor as he was walking down the steps? Did he come out on the balcony and shoot him? No. Did Mason go and like go into the other apartment and start shooting? No. He didn't. The only person that got shot, the only person that got killed that day was the only person that went into his apartment and threatened. That he wanted to, he didn't want to. He didn't want to shoot Trevor, ultimately. But he was going to shoot Trevor if Trevor came into his home and threatened, because the law says you're allowed to do that. And you should, because you are presumed to believe that they are coming in to hurt you. And he did. But of all the things that they try to say, like, oh, well, if he was setting it up, then why did that? Why not just kill him? Oh, well, he wanted an excuse. He wanted to be able to
5 minutes.
Thank you. He wanted to be able to say, oh, he came into my home. Right? Oh, that's what. But you cannot say by yelling these things, which are emotional things that he's upset about, but not things that tell the person to let it come up. You know what that is? Why don't you come up here? Why don't you come up here? Why don't you quit being a little, oh yeah, you slapped me before, why don't you come up here and try it again, right? Oh, that's provocation. Why don't you come up in the house? Why don't you come up to this thing? Why don't you fight here? Why don't you bring Trevor up there into the house? Nothing Mason said would cause a reasonable person to go to use force, do all this stuff, and they're going to go, well, why didn't Mason lock the door then, right? Like that's their big reveal, I'm sure. Why didn't he lock the door? Because he's shutting the door, not thinking that this guy's going to come. But I bet you what did happen is once that door opened, or once he heard it up the stairs, he did go get ready. Because the way the dad described it is like, if he heard that, then yeah, he's going to go, but he wasn't going to shoot one person. Never would have. Not one person that didn't go into his apartment. Right? Not one person. And he did. Trevor was not acting like a reasonable person. I got this. I might catch you. And here's the thing about that. That is the nerve, honestly. The nerve. SAB doesn't believe him ever. Then they don't go get it tested. Then they come in and tell you it might be catched. Well, it might be catched. It's easy and convenient. But imagine how terrifying that is. If you're ever called to have to use force, deadly force, in defense of your home, and the police don't do the investigation, and then they tell the jury that's been seated to decide whether or not you committed murder, that it might be catch-up because we didn't test it. How terrifying. But ultimately, what he's saying is that, I don't know, could be Trevor's blood, could be ketchup, could be Trevor's blood. I don't know. You know what that is? It's a reasonable doubt. You know what that is? They can't rely on that. They can't tell you it might be ketchup. They can't say, we don't know. They're talking about, well, we don't know if he entered or not. No joke. Because it didn't test to figure it out. Because guess what? If that's his blood on the inside of the wall, there's pretty good evidence he was in the apartment. But like Patrick told you, the law doesn't require you to go into the apartment. All it requires is you open the door and you threaten somebody, they can hit you right there. They can't, because you don't have to wait for somebody to go in. I asked Mr. Beeman, I said, what were you going to do to the next person that came in the door? He said, I was going to shoot him. The next person walked in. In his situation, even though there was no danger to Mason, they had a reason to be careful. They had a reason to believe. They had a reason to be cautious and everything else after what had just happened. But not because Mason was in the wrong. But that's how it goes. If somebody even steps a foot in, that's it.
Yeah, 2 minutes.
Thank you. Sergeant, you testify a person doesn't actually have to come in your home. The SAPD did let Mason down. They failed to really investigate or take seriously the problem that Trevor was causing. They failed to offer Mason assistance to the department, and that was something he couldn't do to civil standby. They failed to do any of that. And you still have this guy terrified of this man who is justifiably terrified. I don't know anybody sitting in this courtroom who wouldn't be terrified of that guy if he's your neighbor. I don't know anybody who would. So that's reasonable to be terrified. And it comes back down to this chart. Ultimately, when you go back there, no matter what they say about provocation or anything else, they have not proven beyond a reasonable doubt, able to overcome the presumption that Trevor was not doing it. And it all comes back down to Trevor's actions cost Trevor's death. And the main witness about what Trevor's actions were is Jim Beam. And Jim Beam told it at the time. Because Trevor came in there, opened that guy's door, and he probably would have been tries to shoot himself. That's it. If you convicted Mason, you would be convicted of despite his father, Trevor's father, saying Mason was probably going to do it. And that's a heavy word. Mason does not deserve to be convicted of murder. And we're asking, get to the end of it with the evidence we're asking to find him not guilty, because he is not guilty of murder.
That's fine. I'm gonna give you 5 minutes. You want to shoot it also this way?
Solely and alone. That's what the defense told you. But you know that's not true. You know that 7 rounds fired from these rifles what cost Trevor's death. Where are you deciding that's a murder? You know that 3 rounds into his neck, 1 into his left arm, 2 went into his chest and stayed there, 1 into his pelvis and stayed there. That's what cost Trevor's death. As we told you previously, there's no dispute that we've met the elements of murder. They're not fighting that. He caused the death.
I'll just object as far as murder, because that's
The elements of murder. So the question then becomes, is this self-defense? There's a couple things in the jury charge. The secret sauce, the answer is no. The answer is guilty. On page 6 of the jury charge, the defense talks about this, the presumption. The presumption of reasonable belief applies unless the state proves beyond a reasonable doubt the facts giving rise to the presumption do not exist. I told you we were going to talk about that. He was right.
Your Honor, I'm going to add to that. We can approach that has been excluded from the charge. That language is specific.
Literally number 3 in the jury charge.
The court has found that language should not, that language is excluded from the charge. Provoking the difficulty.
The presumption was we agreed, right?
I understand on provocation, but provoking the difficulty is specific, that's a specific part of the law, they went overboard higher.
And if this is not a case of offensive property, then this is a murder. If we go back to those elements that we proved earlier on, then nobody disputed that Mason Lubitz caused the death of Trevor Beam. Defensive property, I think most of you have heard lots and lots about self-defense. Defensive property may be a surprise to you talking about that. But the one thing I want to really emphasize on defensive property castle doctrine is that there is no presumption of reasonableness. I don't have to overcome that presumption. Was it reasonable to shoot a man in this circumstance? I think the facts clearly show that a reasonable person would not have done that. And I think the facts also show that Mason Lubitz was not acting the way a reasonable person would. Did a burglary even occur? We're going to talk about that a little bit. If they want to talk about assault, you heard the definition for an assault. You also heard from testimony that there are other things, such as criminal trespass, that doesn't make burglary, terroristic threats, a conditional threat. Do you want to get slapped again is different from, I'm going to slap you again. I'm going to slap you again is a threat of assault. Do you want to get slapped again is not. That is not an assault, it's not a burglary. Was shooting a man unarmed 7 times reasonable? No. Defense property doesn't apply here. Let's talk about self-defense. When is to the degree the actor reasonably believes that deadly force is immediately necessary? Was Trevor Beam using unlawful deadly force? No. Was Trevor Beam committing a kidnapping, a murder, a sex assault, an aggravated sex assault, a robbery? The only way he's reasonably entitled to self-defense is if he gets the presumption. That's what this case is about. And he only gets that So I've got two things for you. Did he enter? No. Was he committing burglary? No. Did he provoke? Yes. I'm talking about James Beeman, Trevor's father. Obviously, it's difficult to be in a circumstance. I can't even imagine how difficult it would be to see something like that happen in front of you. A lot of this case, a lot of the closing argument went about what did James see? What did James say he saw? What did he say he saw? Mason poked his head out from behind the door. He didn't step on the landing. He poked his head around. Why was he poking his head around? You could draw inferences from that. Could it have been because he had a rifle strapped around him, ready to go? Trevor took the insults for several seconds. Regardless of who they were addressed to, they want you to believe that he came back and said something completely different. You saw that laundry list of things that he said. Literally, the only thing different from what he said at the time is mentioning Madison. But I hate you, you ruined my life, your son robbed you. And at a certain point, as he said, Trevor had enough. Trevor had enough when he directed those insults at James and said, your son was the one who robbed you. It's not even true. James told he's never been robbed before. But you know what? On Christmas Day, when you're a 24-year-old man hosting your family, trying to impress them with what you made of yourself, your new job as a member of the Army National Guard, and somebody's doing that in front of you, you react. Provocation. He never entered Mason's apartment. We're going to talk about that a little bit more, but the evidence shows that he never entered that apartment. He fired several shots from inside the apartment, and then he said he fired two more as he closed the distance. He didn't say he stood out there and fired through him. He said he fired several from within, and then approached and fired two more, consistent with everything you see in the autopsy. Mason was purple-faced with anger, yelling about his son, about his son's stroke, about his father. And again, I want to remind you, it's not, I'm going to slap you, I'm going to slap the shit out of you. It's do you want to get slapped again? So we're talking about the situation, what would a reasonable person do? A reasonable person on Christmas Day, barefoot with his dog outside, with his dad there, would want to confront somebody to say things like that to him, to his father. That is, so he's changing his story over and over on cross-examination. That was the theme. His shove was shot 7 times in front of him. He was afraid for his entire family. He was interviewed less than 2 hours later, so I think you heard a cross-examination. Like, oh, well, you were in shot. You haven't seen any time for a few minutes. But 2 hours later, clearly you're fine. No, it doesn't work that way. You're not fine 2 hours after your son's murdered in front of you. It's just not the way it works. He said his vision was obstructed. So they want you to say, well, he clearly turned the knob and pushed the door open. Fine, they want to say that. That is what he said. I don't disagree with the statement he put on there. But he said that he assumed that's what happened because that's what made sense in his mind at the time, 2 hours after the shooting occurred. See, this is from the door frame. There's a basket, there's a skeleton hanging from Halloween, which was never taken down. There's a bush, there's a light pole, there's a railing. There's lots of things in the way. Everything's consistent with what Jim said. Testified that he fell straight down. You know from the autopsy that his cervical spine was severed and he fell right down. Absolutely consistent with what James said. James again was seen on that cement eye before. There's a single spot of possible blood that defense want to talk about on the left there, but you can see it's weird looking. Is it blood? Is it spittle? Is it body matter? I don't know. There's also 2 spots of blood on the door, which again, as the second testified, we don't know if the door was 45 degrees open or 9 degrees open or whatever. Blood spatter, you heard about that. If somebody shot standing outside the apartment, their blood will spatter. What was important is where the blood ended with the body fell. And that shows you where he was standing because he fell right down where he was standing. Also consistent with what Jim told you is that 2 additional shots were fired. And if you look at the bullets that did not exit the body, the 2 to the chest and 1 to the pelvis, the wound path moved from right to left, which is consistent with somebody. You saw where James fell, where Trevor fell rather, and you saw that's consistent. If somebody's walking towards that person the way he fell, door here, on his back here, those are consistent with what James testified to. That's where the body fell, 100% outside. What did James tell you? He doesn't know how it was open, he knows that it was. Evidence certainly suggests that Trevor either turned it on and pushed it, or was trapped and pushed it. Certainly that's This is about the specific circumstances in this case. We're not talking about whether caste doctrine truly exists. We're not talking about whether standing ground should exist. We're talking about, did Mason provoke a confrontation to commit murder? If he's coming here to lie to you, to make it look like a murder, why doesn't he tell you things that don't make Trevor look good? He told you he went to the door, he assumes he opens the door, and then he asks if you want to get slapped again. Those are not the things you say if you're trying to make it murder. Those are the things you say if you're trying to tell the truth. He's not here to defend himself. His family loves him. They spoke highly of him. 24-year-old, just from the Army National Guard, wanted to host his family on Christmas. So much felt when they couldn't go to the big house, they wanted to be humble. So what? He chose to host his family and they agreed. It was the insults directed towards the family that led to that response. He's out barefoot with his dog. That's not a guy looking for a fight. That's not a guy looking for a confrontation. That's a guy walking his dog in the morning in front of his dad when somebody tries to start a situation. Again, I talked about this beginning. His actions cost his dad 7 bullets. Cost his dad. Was he drunk? No. The only definition for intoxication is loss of your normal mental faculties or .08, too drunk to drive. If below .08, his family testified he seemed perfectly normal. He was high. That's not true. You heard from the doctor. The cocaine was below the detectable quantity. They've got a threshold where it's a positive result and a negative result. And what their result was, there is cocaine in the system. It's not high enough to quantify. Just so you can see what I'm talking about. Cocaine, minimal undetected. Cocaine, or opiates undetected. Cocaine less than the legal quantitation. And again, 0.062, 0.064 below the legal limit. Not drunk, not high. Hungover, maybe. Look at the blood. He shot outside the apartment. You heard at one point that Mason picked up the body and moved it. That was a track. That body fell right there and stayed right there. There's not 2 pools of blood. There's no blood on Mason's clothing. All of it's outside, except there's 2 droplets in the door and that 1 droplet of potential blood on the inside. What I want to talk to you about, in addition to this, what I really want to point out, we know he was shot standing outside the apartment because the physical evidence shows you that he was. He was shot 7 times. 3 bullets went through him. 2 went through on the neck, 1 went through the left shoulder. And this window, immediately to the left of the door, has 3 bullet holes in it. So you know those 2 and 3 went through that window. We talked a lot about the layout. This is the landing here. This is the half wall here and here. So you're like basically a hallway right here. And you know that the casings ejected to the right or back to the right and ended up in this living area. If Trevor's standing inside this apartment, those bullets can't curve. Those bullets can't go through that window. What that tells you is he was standing outside. And when it went through his left arm and went through his neck, as he's turning the door, leaning in, boom, 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 threw him through the window. That means he's standing outside, just like the blood confirms. Where was Mason? We know he can't be standing where his buckets are, so he's standing back here. Again, if Mason is Trevor standing inside the doorway, and Mason is standing here, those bullets are going to go straight. They're not going to go through that window. Let's talk about Mason. Christmas Day, pulled up in a U-Haul, showed that nothing but his right, low ready. Consider his behavior, consider what he says before the shooting, during the shooting, after the shooting. From the day, October 4th, to Christmas Day, I want to kill Trevor Beeman. It says it many times to many different people. Anybody who will listen, he tells he wants to kill Trevor Beeman. It's not something to provoke it. We know that he's done it before. He insulted his wife. He can't beat me like he beat your wife. That was enough to draw his confrontation, to draw that slap or that punch, that sword. We know that he tried that again because James testified. He said, I hate your son, he ruined my life. I hate his girlfriend or his wife. That wasn't enough until he started addressing Trevor. So, when that didn't didn't work. When he got you before the well, he tried something new and it worked. Words alone can justify assault, but words alone can be provocation. And I want to emphasize that to you because he knew how to push his buttons, and he pushed his buttons. That's what he did. He got what he wanted. What happened? Mason was emasculated. You heard from his girlfriend that masculinity is real important. Then he got slapped or punched and embarrassed by her report. He spent 3 months living from hotel to hotel, motel to motel, because he was stewing on what had happened to him. You heard that he initiated the confrontation with Trevor and with James. And you heard that he built the biggest, most baddest AR he could, and he brought it back. Why did he bring it back? To help him move? Is that what they want you to believe? Are you allowed to have an AR? Yes. Do you need an AR to help you move? Absolutely not. Think about the 911 calls. And to be clear, ladies and gentlemen, I know this is a snow day, a holiday. You're allowed to review any and all of the evidence. There's 911 calls. There's a few we didn't even play for you. Video, you can watch it again if you choose to. Listen to the calls. You can hear from Talmida, you can hear from Howie, you can hear from Mason. What I want to tell you is what Mason says. I was assaulted by someone with a gun. Was any gun used? No. Does he know what that gun looks like? Does he know the gun that he has? That he knows this Istanbul company. That's not consistent with having a barrel pointed at you. You can't see the make of a barrel when it's pointed at you. I feel like murdering somebody. Not that Trevor's a dangerous person who will shoot at them. December 25th. Fury. Think about his statements. He made 3. He made the video statement, he made the written statement, and he made the audio statement. A demon lives in that apartment. Trevor's a demon. His dad, James, says he's a piece of shit, and I hope he does die. Come on. Really? He did not point a gun at me when he punched me. I would have killed him, but he had somebody with him. He was trying to instigate so he could shoot me. On October 4th, he's talking about the pretext to commit self-defense. And he's projecting that idea onto Trevor. But who really had the idea about instigating a conflict so he could justify shooting him? That was Mason's idea. I would kill her. I would kill him. I would kill him in front of her. I could get on top of that guy and end his life. And again, defense even showed you part of this. Call me to the stand so I can testify about how he beats his wife while making faces, winky faces at the camera. I'm trying to get something more satisfactory. What did he want? Exactly what he got. The opportunity to kill Trevor. His written statement, his father and his roommate both think he needs to die. He turned my life upside down. This is what I'm talking about. He spent his days, 3 months stewing on what happened, about how he was emasculated and made him feel less than. He is not bulletproof. We know that's true. The audio video from December 22nd. This has ruined my life. I could ruin his life if I wanted to. Trevor had a murderer with him. You're not going to beat me like you beat my wife, and then he socked me in the face. I don't like to be fucked with, and I'm capable of serious brutality.
That's statement.
It is.
The jury recall the testimony of the evidence.
You can listen to the statement. Are you going to assemble your AR? Yes, I'm going to assemble the most badass AR I can. This is Texas. I'm allowed to protect myself. 3 days. 3 days before, I'm allowed to protect myself because he knew he was going to start something. From December 22nd, I wanted to kill this. Also from December 22nd, I wanted to kill this guy. I should have killed everyone. They sent kids to break the cameras. What are we even talking about here? They put a green light out on me, but an angel let me know. Is this the actions of a reasonable person? I don't think so. I need this done with. I'm out of options of going back on Christmas Day. He didn't request a civil standby, but he did resolve this. He did get this done with. He's furious. The only thing he cares about is his dog. This is a statement to Detective Henning at the police station. Last night I put the AR in my apartment. I'm allowed to bring my AR. I had every right to do what I did. I did everything right. I just killed somebody I shot him to. He's got a checklist and he thinks he's made all the checks on his list. Think about shooting. He has to know the family's there. You heard the testimony that they came in several cars. They had food. They had gifts. It took them several trips, maybe 15 minutes of loading and unloading to get to this apartment. And we know that Mason's watching the apartment because the second Trevor comes out for the first time that morning, he's there. He opens the door. James testified the door was open and he was yelling before James even left. So the defense wants you to think he was only yelling at James. That's just not true. Mason was poking out, purple-faced, angry, and Trevor was halfway down the stairs when Jim came out. Afterwards, after he gets he consults him, consults his girlfriend, consults his dad, shuts the door, doesn't lock it. You know he can. You know, exposure to the deadbolts, and they kick in the deadbolt and tore up the door frame. Afterwards, he does everything he can, to prevent himself from getting shot by law enforcement. I'm going to put the gun down, I'm going to take my clothes off, which is not a normal, reasonable thing that a person does. But, is it effective? I think the outcast was unusual, but certainly would make him feel more comfortable. I can't disagree with that. Again, you can draw a rational inference from why he closed it to lock that door. Defense keeps apologizing. You're doing it in opening, you did it in closing, you're doing it throughout the trial. Keep apologizing, explaining why Mason would be upset after the shooting. Because they know that's not the behavior of a normal, reasonable, rational person.
Definitely. That's the objection. Try to shoulder counsel. That's reading in my motives or whatever else.
Allows probably 2 years total.
You heard the officers testify about how usually the behavior were in years and years and dozens or hundreds of responses and never seen anything quite like it. And he knows that behavior started well before the shooting. Because again, he was angry from the moment he opened that door and started yelling at Trevor and James. If he's scared, why did he come out at all? He's obviously watching through the window. His own girlfriend, Jenna, came in to testify on his behalf. Probably knows him better than anyone else. Does that sound like the behavior of someone who's scared? No. Jenna says that doesn't sound consistent with what he told her over the phone, by a text message on October 4th and October 5th about how scared he was. She doesn't think that sounds consistent with somebody being scared. He's a lover, not a fighter. So what do you think about him going to the biggest, baddest era possible? Does that sound more like a fighter or like a lover? Well, that sounds more like a fighter. She agrees. He wasn't scared. He wanted to fight. Mason is therefore not entitled to the presumption. If he's not entitled to the presumption, and if Trevor's not trying to murder him or commit a kidnapping or sexual assault or any of those things on the list, and he's unarmed, which you know he was unarmed, then he's not entitled to use self-defense, deadly force to kill Trevor. He's just not. That's the way it is. Additionally, even if that was true, we know that Mason knows how to provoke Trevor. That's exactly what he did. He provoked him to do exactly what he did. He kept antagonizing him until he responded, at which point he shut the door and backed up, ready to go. He instigated the October 4th confrontation by calling him a wife beater. Spent 82 days between October 4th and December 25th stewing on his feelings of shame, embarrassment, and emasculation. And he instigated the Christmas confrontation by yelling hate at Trevor, at Madison, and at James. He knew the bait was taken, he closed the door. When the door opened, he was ready to go. 7 quick shots. Boom, 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 boom. Trevor's dead. And if this evidence confirms, the window, the holes in the window, the body, the blood pooling, as soon as he opened the door, he was going to die. And it's tragic that he took the bait he did. What did Mason say? He did everything right. He's following his booklet, check all the boxes. But he provoked the difficulty. He's not
subjecting into the language of the court rule. And then we have a running connection. That's why I don't have to. That's fine.
Christmas Day 2021 was not about fear, it was about rage. This is the only thing that he brought back. He came to that apartment that day, his rifle. And he heard from James' testimony. Furiously angry before, you saw the video, furiously angry afterwards. And you heard, when he was obviously dead, that he came out again. He stood over the body, and he kicked it. He said, get him the fuck away from me. Because he was still mad. He was furious about being disrespected, and he thought that he would be murdered. And I'm asking you to look at the facts and make the conclusion that he did not reason to fear for his life, that he's not entitled to the presumption to use deadly force. That what he did on Christmas Day was murder. And that's been convicted of murder